In the meantime, it's worth recalling that the new techniques were approved for use even before the memo was written and signed off on. The Rumsfeld memo, the authorizing document, actually post-dated the beginning of their use. As Diane Beaver told me, on the 23rd of November 2002, there was a voco. For some 54 days, Al-Qahtani was subject to every single one of the 15 techniques of interrogation. His interrogation log is publicly available. I gave a copy of that interrogation log to a clinical psychiatrist in London who's the leading expert in my country on whether or not someone has been tortured. She read it very carefully over several days. We met on a couple of occasions. And I wanted to know from her whether Al-Qahtani's treatment constituted severe mental or physical pain and suffering, which is the test for torture in the 1984 Convention. I describe very much more fully her account in my book, and it was one that I think she considered very, very carefully. But the sum of what she said was this: if you were to take 12 clinical psychiatrists and put them in a room, give them this document, they'd all conclude they need to meet the guy in order to form a final view, but on the basis of this material, it plainly crossed the threshold of torture. Most striking for this doctor, Abigail Seltzer, was the use of cumulative techniques designed to humiliate and subjugate over an extended period of time. What I discovered was that the new techniques were indeed authorized in circumstances in which the traditional decision-making processes were simply bypassed. I picked up from one interview a nugget which suggested that once General Hill's request had reached General Myers, Mr. Haynes had intervened to short-circuit the decision-making process. I'd spoken to some people off the record, and that's what I was told. This has now been confirmed in open testimony in congressional hearings in June 2008, after my book was published. Because when the document reached General Myers' office, he passed them on to his lawyer, Jane Dalton, who began the usual departmental-wide policy and legal review of the techniques, at which point more senior and experienced military lawyers became involved. Some immediately expressed a strongly negative view, and as Jane Dalton had told me, and as she testified in Congress, she then passed on those strongly negative views in the first week of November to Mr. Haynes, or at least to his office. She assumed he had read them. What happened then? Very shortly, Mr. Haynes intervened to short-circuit and stop the decision-making process. This is actually a most crucial of all the facts, because if one were putting forward a defense for Mr. Haynes, it would be the argument of good faith. That argument collapses in the face of what he appears to be, on the testimony of Jane Dalton, a clear desire on his part not to receive any bad news from the lawyers who actually know something about these techniques. What I also established was that everyone who actually knew something about these rules, the Geneva Conventions and so on, in the military, in the Department of State and elsewhere, were simply cut out of the process. And I also established, without any ambiguity, that by the time Mr. Haynes intervened at that stage in November 2002, in the first week, he didn't need to rely on Diane Beaver's legal advice, because by then he already had knowledge of the contents of the legal advices written by the Department of Justice, by Mr. Yu and Mr. Bybee. Because when he accompanied Mr. Addington down to Guantanamo on the 25th of September 2002, he already knew that the Department of Justice had signed off on these new techniques. And in the US system of government, he would have known that once the OLC has signed off, that is it. There's no debate. Diane Beaver emerges in that context as a useful scapegoat. In mid-December, as Al-Qahtani was being abused, word reached the Pentagon as to what was going on. A number of people at Guantanamo, in the military, in the Naval Criminal Investigation Service, in the FBI, contacted Alberto Mora, rather heroic General Counsel of the Navy, in the Pentagon, down the corridor from Jim Haynes. His story has been widely told. He intervened directly with Jim Haynes in circumstances which eventually led to the end of the use of these techniques on the 15th of January 2003. What's the upshot? By speaking to people directly, I was able to reach a conclusion, rather clear in my view, that the narrative the administration had spun in June 2004 was totally false. The administration, firstly, did not move with care and deliberation. The decision at a policy level to move to harsh interrogation techniques, if not torture, was taken as early as December 2001. The law simply followed the prior adoption of a policy that was already fixed. Second, and most significantly, the initiative didn't begin on the ground at Guantanamo. It came from the top, the very top. That too has now been confirmed as a result of hearings that took place following the publication of my book, which established that it was Mr. Haynes himself who initiated the search for new techniques of interrogation in July 2002, more than 3 months before Diane Beaver was called upon to give her legal advice. Third, the legal justifications for the new techniques did not come from Guantanamo Bay or from Diane Beaver. It was plainly the result of the legal positions that were taken by the Department of Justice lawyers, and in particular reliance on the 2 memoranda of the 1st of August 2002. I've mentioned that I had 2 meetings with Mr. Haynes. He was the last person that I spoke with. Mr. Haynes was the only person who before then had said constantly no to my request for an interview. A journalist friend of mine at the New Yorker suggested that I write what she called a Bob Woodward letter. Just 3 paragraphs. Paragraph 1, here's the list of 19 people I've spoken with. Paragraph 2, here are the 3 worst things they say about you. And paragraph 3, this is your very last opportunity to give me your account. And it worked. It opened the doors, and in I was for the first time to the Pentagon. Huge place. I hadn't appreciated how enormous it was. 2 formal meetings with Mr. Haynes, both off the record. The agreement was that the conversations would not be addressed in the book, but the fact of our meetings was not, an important distinction in which the press office of the Department of Defense fell into error. So in the book I could refer to the fact that we had met, but not precisely what he and I had talked about. What I can say, as I do say in the book, is that all of my conclusions, both today and in the book, take the fullest possible account of everything that Mr. Haynes said to me. An astute reader can form her own view as to what he said, or its force. Fourth, my account knocks on the head the administration's claim, which denies any relationship between events at Guantanamo and events at Abu Ghraib. Major General Dunleavy's successor, Major General Jeffrey Miller, and Colonel Beaver traveled to Iraq and Abu Ghraib in August 2003, and amongst others they met with General Sanchez, who on the 14th of September 2003 adopted new regulations on interrogations, and these included many of the same techniques that were authorized by the Rumsfeld memo: hooding, stress positions, removal of clothing, use of dogs, etc. And of course they're the very same images that we associate with the pictures of abuse at Abu Ghraib. A month later, in October 2003, the abuses began. The Inspector General of the Department of Defense, no less, has concluded in a thoroughly damning report published in 2006 that there was clear migration from Guantanamo to Abu Ghraib of these same techniques. And all of this raises a most fundamental question. How could the lawyers who were involved at every stage of the decision-making process have acted as they did? How could they have determined that the rules reflected in Common Article 3 of the Geneva Conventions were simply not applicable to all of the detainees at Guantanamo? How could they have been involved in the preparation of the techniques, and how could they have been directly involved in their authorization? That's now a story that we know my account has really not been challenged. In the end, real responsibility centers on a small group of politically appointed lawyers who happen to adhere to a particular ideology as to America's place in the world and its relationship with norms of international law. The lawyers who knew the rules, who had lengthy experience on these issues, were entirely circumvented. The military lawyers, uniformed military lawyers, were cut out of the process. The Department of State lawyers, Will Taft and his team, were cut out of the processes. All normal checks and balances were avoided. That was done with care and deliberation.